Hi everyone, you're watching the Virtual Amicus and I'm Jay Loda. So today's topic for discussion would be on interpretation of statutes. Now, what do we mean by interpretation or construction of statutes? We often hear about that the courts must carry out the intention of the parliament. Now, how does one understand what the intention of the parliament or the legislature is? What are these rules that govern basic interpretation of statutes? How does it help in the correct understanding of law or any of the concepts? Now, what is the difference between interpretation and construction of a statute? Statute in normal, ordinary terms would be defined as a will or order of the legislature, which is expressed in the form of a text. Now, interpretation helps in determining the real meaning and the intention of the legislature, while on the other hand, construction in ordinary language would refer to ascertaining the legal effect of the legal text. So that is what is the difference between interpretation or construction at the very peripheric level. So to elaborate further, we have with us the keynote speaker for today's session. She's also the amicus for today's session. We have with us Ms. Sakshi Srivastava. And just to give you all a brief introduction about our amicus for today's session, Ms. Sakshi Srivastava graduated with BA LLB honors from National Law University, Jodhpur in 2013. She was a topper of Constitutional Law honors stream. She has been practicing in Rajasthan High Court and the Supreme Court of India as a miscellaneous lawyer for the past 8 years. And her specialization includes writs, dispute resolution, and service law. She's also represented a number of multinational corporations in various high-stake arbitration matters. She's been a panel lawyer for the RPSC, the RSRTC, Rajasthan State Cooperative Bank, Jaipur Vidyut Vitran Nigam Limited, etc. She's also been the founder, editor-in-chief of Constitutional and Administrative Law Quarterly, which is CALQ, a flagship journal of NLU Jodhpur. She served as a student chairperson of the Legal Aid Committee in NLU and is currently also actively engaged in legal aid cases as a litigating lawyer, especially pertaining to human rights and women empowerment. Now, Sakshi has an LLM degree in criminal law and is a visiting faculty at MJRP Law University, Jaipur. She is also an incoming master's student at Columbia University in New York. So thank you so much, Ms. Sakshi Srivastava, for taking out time on a working day. And the topic is extremely interesting. It is interpretation of statutes. Now, when I was a law student, there was a query that was posed to me by one of the teachers. And when she had asked me to give me the difference between the word or and the word and in terms of legal interpretation and construction. And till date, it has been a struggle to understand. So I hope that after this session, I'm able to understand the difference between and or and when is it used and how is it interpreted. So the floor is all yours. The stage is set. Over to you.
Thank you. Thank you so much, Jeff. So the topic that I would be talking about, as Chair mentioned, is the interpretation of statutes. It's a very neglected subject of law schools usually. It receives very less love. But I believe it's one of the most fundamental subjects that are taught there. Because, the essence of being a lawyer is not to know what is law, because that is just one Google search away. What's important is to know how to read law, the whys of law, the hows of law. And this is where interpretation of statutes with its all techniques and theories comes into play. So I have prepared a PowerPoint presentation also. So I'll keep sharing some slides in the middle, and I hope we learn a thing or two from here. Give me a second. Okay. So the first question is, why do we need to know why do we need to study this subject at all in the first place? As Lord Denning had once famously remarked in his Seaford Court Estates case, is that the English language is not an instrument of mathematical precision. So basically, it's a language, it's not a mathematical formula. So whatever I may mean to say and whatever you may mean to hear, understand, or interpret there will always be a difference. And that is why the techniques and the tools of interpretation of statutes are used to understand the intention and the purpose behind any statute that has been enacted by the lawmakers. And the modern day statutes, as we know, are often ambiguous, they're complex statutes, there is ever evolving social conditions. So in light of all of these, it's important to know what techniques or what tools of interpretation have to be used to understand any particular statute by the court. Now, the philosophy behind the subject also is somewhere to find a balance between two things. As we know that we are a common law country, we have three pillars of federal structure, that is executive, judiciary, and legislature. The legislature represents the will of the people, it formulates the law, and the judiciary is supposed to basically apply that law to particular scenarios and disputes. We have a separation of powers between these three pillars. But on the other hand, in a common law country where judicial precedents also form parts of law, in a welfare country like ours, where the courts always try to give beneficial construct to statutes, we have to find a balance between these two things. We have to find a balance between what judiciary actually interprets for the purpose or for the betterment of the people, any statute, and what exactly was intended perhaps as in the text of the statute. So we'll see what are the different techniques, what are the philosophies behind this interpretation of statutes. And as let me just mention, we also have a General Laws Act 1897, which is one of the essential acts in this regard. This contains the general definitions of words like, say, time, place. So which are words which are used across the statutes. But we're not dealing with this in this presentation. What we are dealing with right now are the philosophies behind this subject, and what are the various techniques that can be used. So, yeah, coming to this, one second. Yeah. So the first technique that I will just tell you about briefly is there are four canons of interpretation of statutes, basically the four philosophies of it. The first is the textual school. There's basic textual school, then there is golden rule, there is the mischief rule, and then there is purposive construction. So these are they are start from the most conservative to the most liberal approaches. Now, the textual approach is based on, obviously, this is the oldest method of interpreting any statute. This is based on strict doctrine of separation of powers. It believes in parliamentary supremacy. It is also called rule of plain meaning, or the literal interpretation as we often know it. Just basically means that the words have to be understood in the natural, ordinary, popular grammatical meaning. Now, we often hear, especially in the context of American jurisprudence, a particular judge is conservative, a particular judge is moderate, someone's liberal. So what does that basically mean? Look, although in India, the judges do not really brand themselves like that, but in the American jurisprudence, we hear stuff like that very often. It basically just means that, how the judges are actually interpreting the statutes made by the legislature. So for instance, Justice Scalia was a textualist. He was an originalist in his approach. He believed in this school. Then we have someone like Justice Ginsburg, who was a liberal judge because she believed in more liberal construction of the statutes. So that's how this goes on. Now, another is for instance, I'll give you an example of a case of textual approach. There was a case called Fisher versus Bell in England. And so what happened was, at that point of time in UK, there was a law called the Restriction of Offensive Weapons Act, which prohibited sale of offensive weapons. This man displayed a knife in his shop, and the police arrested him. But he argued, so the court let him go free because they said that displaying a knife in a shop, basically under Contract Act, is only an invitation to sell. It's not an invitation to offer to sell. So it's like a tender. So that is why the court just went into the direct text of the Contract Act and they let him go scot-free. So this is a textualist approach to interpreting any statute. Now, there are limits. Obviously, the limits emerged to such a school, or you could say approach. So one limit is there is rule against surplusage, which means that basically if there are two interpretations of a text and one of them is causing to read the statute as redundant, then you will always always follow the second approach. And the other limitation is doctrine of absurdity, which basically means if the plain reading of the law gives an absurd meaning, then you have to look beyond it. Then you have to look at the purpose and the intention of the statute. So this gives way to the golden rule of construction, which has also often been used by the Supreme Court. For instance, in state of Himachal Pradesh versus Pawan Kumar, the Supreme Court had held that if the literal interpretation is inconsistent or contrary to the plain reading of the case, it may lead to absurdity, repugnancy, or inconsistency in any way, then the grammatical meaning has to be modified and it has to be, applied to counter that absurdity. Now, the onus of this, however, that the plain meaning is absurd, lies in the person who's alleging it. The golden rule also is of two varieties. First type of golden rule is the narrow golden rule, which comes into play when it is applied when there is an ambiguity in the text itself. Now, for instance, I'll show you by example. There was a case of R versus Allen in England, which was a case against bigamy. Now, what happened was the bigamy law was just plain and simple. It said that any person entering into a second marriage will be held liable for bigamy. But now, technically, when your first marriage is already legally recognized, there is no second marriage, right? Because that is not going to be legally recognized marriage. So that way, nobody will ever be prosecuted for bigamy. So what the court really interpreted, they went behind the purpose of the statute and they said that the second marriage here does not mean the legally accepted marriage. It basically means the procession, the process of marriage. And even if it's not, it does not have legal sanctity. So this was, they applied this golden rule of construction. Another golden rule approach is a wider approach. In here, even if the text is prima facie very clear and not ambiguous, what they do is the judges sometimes, to uphold the principles of public policy, will go behind and look at the purpose of the act itself. For instance, in Adler versus George, there was a case where the rule said that a person cannot obstruct a military serviceman in the vicinity of the industrial establishment. This particular person, the plaintiff, the defendant, had obstructed a military serviceman inside an industrial establishment. He argued that the term vicinity, technically just means outside the establishment. So anything done inside the industrial establishment is technically not vicinity. So even though the prima facie meaning of vicinity is different, yes, the court went behind the act, and they looked at the purpose of the act and they held him guilty on this accord. So next, I'll just share a slide one here because there's something to read. What we have next is mischief rule, which is, so if you notice, we're moving from text with like the strict interpretation to more liberal interpretation. The mischief rule was upheld, it was enunciated by Lord Edward Coke in Hayden's case in England. So it basically means that what we have to look at is what was the common law before. So while we're interpreting any statute, we have to look at what was the law before, what was the common law before that statute. Then we have to look at what are the problems arising, in that, what was missing from that common law or those statutes of those times. How has Parliament, made efforts to cure that defect or that mischief, and what exactly is the reason of that remedy that has now been provided in the new statute. So as you see, they said that I will just read it out. They said the judges must always make such construction as shall suppress the mischief and advance the remedy according to the true intent of the makers of the act pro bono publico, which means in furtherance of larger public good. However, the Supreme Court in Torra Devi's case had held that, it's said that unless there is an ambiguity, a clear ambiguity in India, we will apply golden rule only and only in those circumstances. So yeah, after this, we have something called purposive construction, which is the most liberal approach in the canons of iOS. In this, what basically we have to see is that the judges go and look at the intention and the spirit of the statute. If they do not just look at the plain text, they have to also look at the purpose behind it. And this is different from the mischief rule. This is one step ahead because, as I said, in mischief rule, what we are only looking at is the gap between the old rule and the new rule and how the new rule has filled that gap. But here, even if there is no gap, there is no comparison with the known law. What here we need to do is what was the end goal that the parliament was trying to achieve? We have to look at that before we construct any statute. I'm sorry, before we interpret any statute. Now, for the purpose of construction, there are two elements, subjective and objective, which any court would look at. Subjective element is that they have to look at the intention of the author of the act, that is the parliament in this case. And objective interpretation is that they also have to look at the intent of a reasonable author, and the fundamental values of the legal system that are prevalent. So this is often obviously a criticized approach as well sometimes, because this can be interpreted as judicial overreach often. But you have to sort of this also gives way to beneficial constructions. However, like in a country like India, social welfare legislations are often part of our legal system. Purposive constructions have played a very pivotal role. And judges obviously rely on various extraneous materials like drafts, Hansards. Hansards are the text of parliamentary debates in England. And in India also, now we rely upon parliamentary debates, committee reports, side papers. These are the external tools that we often use. And that's how the liberal approach to interpretation works. Now we have also, I will just go through with you guys some other rules of construction. These include some legal maxims. So these are going to, they will help, not only law students it gives this interpretation of statute as a subject, gives a jurisprudential insight into, as I said, into law to law students. And for lawyers also, litigating lawyers can use these to, make the draft better, and to, this should also help in legal research if we use them in our practice. So the rules of constructions are also usually, they belong to two schools, a strict school and a liberal school. So the first maxim that we have here is expressio unius est excluso alterius, which means the expression of one is the exclusion of others. So basically, when a text is, when any word that is written in the statute by the parliament or the lawmaker, we have to assume that whatever has been written is written on purpose, and whatever has been excluded has also been excluded on purpose. For example, we can take the case of rape. In India, only a man can rape a woman, while many might argue, but the law does not recognize a man raping a man, or a woman raping a woman, or even a woman raping a man. So that might, be against what a lot of human rights propagators might want to, have the law as. But since IPC, the statute clearly mentions only a man raping a woman, the courts have always interpreted it like this. Then another, obviously in pari materia, that's a very common maxim that we use, which basically just means upon the same matter or subject. That is, when a statute is interpreted, sometimes if it's ambiguous, we can also look at other statutes with similar subject matters or scope. This is often used in labor law legislations, for instance, definitions of say workmen or industry. They're often borrowed from different legislations, similar other legislations of labor laws. Adjusted generis, that means the same kind of class. Now here, as I would read, particular words have a common characteristic, and the general words that follow should be construed as referring generally to that class. So basically it means that, for instance, when a statute is talking about what exactly, if they're talking about a particular class of things that it is applicable. For instance, a statute says that it is applicable to cars, scooters, and motorized vehicles, for instance. Now, you cannot claim that motorized vehicles also would include an aeroplane. Technically, aeroplane is also a motorized vehicle, of course, run by power. But when you see the word motorized vehicles, it has to be read in tandem with the preceding words, which are like cars, scooters, etc. So you have to, they belong to a certain class. So the act will only be applicable to vehicles like four-wheelers or the land-based vehicles. So this is something that has to be used and has to be interpreted using maxims like this. Then there is nocere sources, which is basically means that it means that word is known by the company it keeps. That if there is an ambiguity, the words has to be read and interpreted in association with the words around it. So there was a case of Stonecraft Enterprises versus Commissioner of Income Tax. So what happened was that there was no deduction for in the Income Tax Act for mining of any minerals, mineral oils, or ores. However, the word granite was not mentioned. So this person claimed that granite is technically not a mineral or an ore. So therefore, he should get deductions in his mining. But the Supreme Court said no. The Supreme Court said that the word granite has to be read along with these words, minerals, oils, and ores. And because they belong to a similar group, therefore, there will be no deduction on income tax, even on granite mining. Then there is contemporanea exposito est optima et fortissima in lege. This basically just means that we have to look at the time at which the statute was passed, and that will provide us the purpose and the context in which the lawmakers intended it to be. Generally, as specialibus non derogant, it just basically means that if there is a general law, if there is a special law on a particular topic, and a general statute, comes after that, succeed, then it is not going to necessarily repeal the preceding statute until there is a specific mention of such a repealment in that statute. So that's how you would interpret it. Next, we come to the liberal schools of maxims. So we have a rule of reasonable construction, which is utrecht meges valiat quam periat. Basically means that the words or any provisions of the statute have to be construed liberally in a way that gives a reasonable meaning to the interpretation. Now, there was a case of Bhagwan Das Agarwal versus Bhagwan Das Sanu. So what happened in this case was, it was a case for Transfer of Property Act. So there was notice to quit. Now, the fact of the case was that it was a monthly tenancy. And so the notice to quit should have specified that. But the notice to quit in this case just specifies that you have to quit tenancy within the month of October 1962. So the other party claimed that because you've just said within the month, so it is not clear that when is exactly it's getting terminated. So it is not relevant, and we've actually not received any notice in law. But the Supreme Court said nothing doing, and they gave a reasonable construction to this. And they said that it is going to be allowed and it is going to be considered a notice to quit. Now there is rule of harmonious construction, which is in CI. So rule of harmonious construction is also used, if you remember, in constitutional interpretations. For instance, constitution is obviously not technically a statute, but a lot of these rules are used there as well. So in the constitution, we use it under 7th schedule when we are balancing the powers of state and central legislature. In the statutes, this particular case had laid these ground rules that the court has to, if there are two contradictory provisions in a particular statute, the court has to avoid the head-on clash between them. The courts have to interpret that there is neither of the provisions should be, rendered dead or irrelevant. You cannot defeat the other provision. You have to give harmony between both the provisions. And the final rule is the rule of lenity, which is that while construing an ambiguous criminal statute, the court should resolve the ambiguity in favor of the defendant. This is basically the same as innocent until proven guilty beyond reasonable doubt. So this is also a rule of interpretation specific to criminal statutes, of course. Then after this, we should presumptions while interpreting the IOS. Like the presumptions in the subject of IOS, basically, which are common to both textual and liberal schools, are like the courts have to keep certain things in mind. For instance, the first is that all the words that are there mentioned in the statute were intended to be mentioned in the statute. You cannot just say, like, you cannot assume that the word was not what it meant. And obviously, as I mentioned before, the purpose of construction, however, sometimes go beyond this. Purpose of construction sometimes will also allow a judge to add certain meanings, to ignore certain words. And that is why it is a little controversial form of interpreting statute. especially especially in, say, countries like England, where parliament is deemed sovereign, or even a country like India, because this is going to render perhaps democracy as redundant if the courts, which are like not democratically elected exactly, start giving their own meaning to the statutes. So this might be a little too extreme form of liberal interpretation of statute. So what you generally assume or presume is that every word was intended to be there. Second is the state is not affected by any statute until it is expressly mentioned that the state will be affected. Another presumption is that a statute is not intended to be inconsistent with international law. Now, unlike US, we are not a monoist country, so international law is not automatically a part of our law. And in case there is, like it's the national domestic law and the international law are different, and so if there's a clash between them, so obviously national law will always have the primacy. But before that, the courts will always try to harmoniously construct it. They will always try to choose if the two interpretations possible, they will always choose the interpretation which is more in tandem with the international law. Another presumption is that the doctrine of natural justice will always be applicable if a statute is giving some power to a particular body or a person, then it is assumed that it will be exercised in accordance with the principles of natural justice. Another presumption is that there has to be no mens rea. Now, we may often see that in administrative law cases, for instance, we allege mens rea on organizations and departmental hearings and so many things. But for legislature, there is no mens rea. So while interpreting a statute, the courts have to work on the presumption that the parliament represents the will of the people, and it always had the best intentions before making any statute. Now, I'm not sure how true that is, but that's what the presumption says. Now we come to aids in interpretation. So basically, there are two varieties of aids. Internal varieties, that is, these are the tools that courts use for interpreting any statute. The internal tools are the ones that are found within the text of the statute itself. The external tools are used in the liberal approach, which are found beyond the text of the statute. So I'll just go briefly through all of them quickly. So coming to internal trades, we have title, the long title, which sets out the purpose of the act. It often precedes the preamble of any act. So it is a very valid tool for interpretation because it obviously clearly elucidates what is the purpose of any statute. And there are also short titles, which are descriptive of the clauses and provisions that follow, but they are not often used and they're not often considered as important as a tool for interpretation. Second, we come to preamble. Now, preamble is the interpretation of preambles is very similar. Sorry, the reliance on preamble is very similar to how it is in the Constitution preamble as well. But preambles are a part of the statutes also, but they cannot in any way control, qualify, or restrict the main enacting provisions of the statute. So only when the Supreme Court also held in Kamalapura, Kochuni versus State of Madras, that only the preamble can be legitimately relied upon or consulted in case there is any ambiguity in a statute and where you have to make out the real scope of the statute. But it cannot be used to restrict the plain words of any enactment. Then there are headings of a chapter or a prefix, or if they may be prefix to sections or schedules or entries, they also have the same rule as preamble. They are considered the part, they're considered a tool, but only when there is ambiguity. They cannot restrict the scope of the enacting statute or increase it in any way. Now, margin and notes, those are the side things that are usually mentioned next to the clauses. Now, in the UK, it's a very clear rule. They are not a part of they're not at all a tool for interpretation. In India, the Supreme Court in Sarabjit Rik Singh versus Union of India has said that usually we do not rely on that, but sometimes when you have to give a different meaning to the provisions of the enactment, they can be relied upon. If the situation is different in case of Constitution, in Constitution, marginal rules are considered a part of the Constitution. And we do, for instance, Article 286, which talks about imposition of tax on the sale or purchase of goods. in that case, the Supreme Court had relied upon the marginal note while interpreting that article. But as I said, constitution is not exactly a statute. So in statutes, we would hardly rely on these. Now, there is something called interpretation clauses. That is, they talk about the definitions in each act. There is exclusive and inclusive definition both. Now, the definitions are part of, obviously, the statutes, but they have to be ascertained from the context of the scheme of the act, the language, the provision, and the object, obviously, that is intended to be served. There is obviously proviso, which is also considered a part. Then there are illustrations and explanations. Now, illustrations cannot modify the language of the section or curtail or expand the scope. And explanations are often added, as ex abundant cautel, as to say, like as a way of abundant caution. They sort of are only meant to clear up any ambiguity or harmonize it. And that is why they should only be read only into that limited context of that and not increase the ambit of the enactment in any way. Schedules are part of the statute. They must be read together, obviously, but they cannot prevail against the express enactment. In Ramchand textile case also, the court had held that in case there is an inconsistency between the schedule and the enactment will always prevail. Now, an interesting thing I would like to show you is this slide. Yeah, punctuation. So these are very minor tools of aids of construction, but they sometimes can make so much difference. If you can read like this, in Muhammad Shabir versus State of Maharashtra case, how a comma made a difference. So the punishment provision of Drugs and Cosmetics Act 1940 said that whoever manufactures for sale, sells, stocks, or exhibits for sale or distributes a drug without a license is liable for punishment. The Supreme Court, however, pointed out the presence of a comma after manufactures for sale and sells and absence of any comma after stocks. So basically, this means that if you just merely stock the drugs, you are not liable for punishment. You're liable only if you're stocking for the purpose of sale. And that is the difference, this whole thing was the difference was made possible just by a mere comma. So that's how, sometimes these tools can be of so much importance. Then we have what we call external aids of interpretation. External aids, one of the most common ones are obviously parliamentary history. That is, we look into the debates and they give us some insight into why a particular act was made. So there was a famous Pepper versus Hart case in England, which allowed Hansard, as I mentioned before, other texts of the parliamentary debates. So before that, relying on, the courts could not rely on the parliamentary debates. That would have amounted to a breach of parliamentary privilege. But after this particular case, the courts, went into the debates. They wanted to actually, to cull out what was the purpose behind any particular enactment or a particular statute. Then we also have references to reports of committees, for instance, and commissions. In a case called Rogi versus State of Kerala, the Supreme Court had relied upon Law Commission's 41st report while interpreting a provision of CRPC. Then these days in European Union, for instance, we also have something called Travaux Preparatoires. It basically means that whatever the treaties and conventions and statutes that need to be interpreted, so you can also look at the preparatory records such as reports and other historical material of these treaties. So now universally, these are considered as important external aids of interpretation. But these all are obviously used only when there is ambiguity and not against the literal meaning of the text. Again, there are also other external aids, for instance, reference to other statutes, but only pari materia statutes, which have the same subject and scope, can be used. Even sometimes repealed statutes can be used to know how any particular word can be interpreted. Again, there are another thing is the regulations that are made under the statutes. So usually the regulations will not have much value, but sometimes the courts can rely to see how the executive or the government in its functioning have interpreted a particular provision and a particular definition. So they may, use the same definition in their statutes as well. Dictionaries, another aid. Dictionaries, like we all have used Black's Law Dictionary at some point, I think. So the courts all use it as well. But Now, what we need to maintain a cautious approach here is that sometimes the literal or the legal meaning of the words may be different from the literal meanings of the words. So it is important that the word is read in that particular context only. Use of foreign decisions only of very material jurisdictions. For instance, we're a common law country, we can rely on foreign decisions of courts like England, for instance, and they may also help us to interpret a statute. Judicial decisions and precedents. Now, sometimes what happens is that cases are based on, like, some statutes are based on cases. For instance, the prevention of sexual harassment at workplace. So it was a judicial case, and then an act was made on that. So in scenarios like that, sometimes, to interpret a particular clause of a statute, the reliance can be placed on the judicial precedents which gave way to such a statute in the first place. Other materials are like books, journals, papers, articles, which are published by scholars and experts in the field. And then finally, one of the controversial external aid is of an extreme liberal approach, which says the social, political, and economical and scientific developments of a society should also be seen. Now, this belongs to the liberal school, of course. It says that the enactment might have been made at any point. It's different from that other maxim that we had seen, which talked about the purpose of that time, purpose of the enactment at the time of which it is made should have been same. But this approach says that what you have to look at is that the statute may have been made at any time, but because at the point of time that you're actually interpreting it, the social, political, economic, and scientific conditions of that time of the society should and must play an important role in interpreting the particular statute as per the changing and evolving times. So that brings us to the end of the presentation. I hope you guys enjoyed it. If you guys have any questions, then maybe you can ask me in the YouTube comments, or you can get in touch on LinkedIn, whatever. I would love to have any discussions on any of the topics. Thank you.
Thank you so much, Ms. Sakshi Srivastava. It was a performance par excellence, and it was a brilliant discourse. So I congratulate you on that. And on a lighter note, I must salute you for displaying and showcasing courage to give a presentation on a subject that otherwise no other speaker would in normal course. Because it takes a lot of courage to give a presentation on interpretation of statutes. So I'm sure all the viewers will immensely benefit from this presentation, and our email is already mentioned on the channel. So all the viewers who are watching, if you still have any queries on any of the fundamentals or concepts with respect to interpretation or construction of statutes, feel free to write to us. We'll forward the same as it is to our keynote speaker, amicus for today's session, Ms. Sakshi Srivastava, and you can even directly write to her. So thank you so much, Ms. Sakshi Srivastava, for taking out your valuable time from your busy schedule. Great. And
thank you so much.
We hope to see you soon for on another subject, different subject altogether. And thank you. A big thank you to all the viewers.
Thank you so much.
Of course. Stay tuned. Next episode is on its way. Please stay home. Please stay indoors. Venture out only when it's essential. Please like, subscribe, share my channel. Goes without saying. So thank you so much, everybody. Thank you so much, Ms. Srivastava. It's goodbye for now. Thank you.